And now it's over to you for questions. We're supposed to go for a break right now, but I'm going to steal, if I may, 5 minutes of your break, unilaterally and with impunity.
I'm Colleen Theron. I'm a director of CLT EnviroLaw. I have a question for Roper, but somebody else might want to comment as well. I'm particularly interested in the comment made about where grievance mechanisms are not being used, or people are saying that there are no complaints. And I'm just wondering if in your project you've come across instances where there are communities or labor conditions where most of the people are either in bonded slavery or in human trafficking circumstances, and they are afraid or distrustful to actually engage in any way with grievance mechanisms.
Okay, I'll try and cover all of that. First of all, in terms of vulnerability and individuals trusting the grievance mechanism, that is one reason why we emphasize this as part of a broader community engagement strategy, and that must be very robust for the grievance mechanism to work. Because it is about understanding levels of vulnerability and understanding that there might be segments of communities who are facing significant barriers. Also, just to stress there that a mechanism should be set up to be able to deal with anonymous complaints, and we've spent a significant amount of time discussing and looking at how you can ensure that something is raised in a way that will be kept confidential, particularly if the complainant is concerned about recourse.
Fiona Gooch from Tradecraft. Thank you very much to the presenters. Tradecraft is a fair trade business, and we believe that trade done in the right way obviously has fantastic impacts internationally. We're very concerned, obviously, about the gap and the need for a framework to guide business practices. My question is in relation to the experience of the non-judicial, which is, in separate work that we have been doing looking at unfair commercial practices, we noticed that the voluntary mechanisms are far more effective and are used more when the alternative state-based system looks a little bit frightening. At that point, the non-judicial or the company grievance mechanism might be more effective. Out of your different case studies, were there any case studies operating where there was some sort of decent domestic law for human rights, and could you see a difference in the quality of company grievance mechanism outcomes?
In response to different environments, legislative and judicial environments for where if that affects the types of grievances coming through. Just to emphasize, some of these projects are in North America, so I won't get into a debate about what you see as a strong judicial environment. But there are still significant complaints and concerns and usages of grievance mechanisms in those projects. Interestingly, particularly with unconventional assets. I think it can work in a range of environments.
OECD guidelines, and if we use that and try to make it more useful for our victims, it's obviously because domestic legislation is not always or either in place or helpful for our victims, but at the same time these non-judicial grievance mechanisms are not about liability. They are not about remediation for the past also, and they're usually based on the goodwill of the company. So it's really not enough, and that's why we're in need of a real strong judicial mechanism.
Thanks. Shanta Martin from Lee Day. I'm afraid this one also relates to grievance mechanisms, so I don't know if you want to ask another person.
No, we'll do all the grievance together. Thank you.
I was very interested in the variety of different cases that IPECA seemed to be looking at. I was wondering if you also looked at, in that project, what were the types of grievances that were being brought forward and whether there were different recommendations as to how to respond to different types of grievances, particularly to address the point that Ruggie also notes in the guiding principles about how the company-level grievance mechanisms, it's important that the company is not both, paraphrasing, but judge, jury and executioner. And so, for example, if there were cases that were to do with grievous bodily harm, rapes, deaths and so on, were there recommendations as to settlement agreements that didn't preclude legal action? Were there recommendations to refer those sorts of cases for criminal investigation? What were the different responses?
That's a very good question. One of the things we have found is that these are often operational matters. A lot of them, not all of them, but a lot of them can be due to kind of the impact of operations on your community, increased traffic, noise, odour, dust, those types of concerns. But I would also stress that what makes it an impact relating to a rights-based impact also relates to the context, so that we often use the one man, two goats example. So if a man owns two goats and one of those goats is accidentally killed by a contractor's vehicle, that has a significant impact on his livelihood. Therefore, it can be a human rights impact. If a goat is killed and it belongs to someone who has a herd of 1,000 goats, that is still something that requires recourse, and it does impact, but not in the same way. So it's, the way you look at it, it's about having a human rights lens to the way that you understand impacts. And then on the impartiality question about being judge, jury, and executioner, it is important to have appropriate checks and balances in place. And also, just to stress, it's important to have some kind of appeals mechanism as well. And in some of the pilot projects, that is looking at and bringing in a trusted third party that both the company and the complainant can trust.
Thank you. Chris Esdale at Lee Day. The initial response from business and from governments to the idea of a treaty has been lukewarm at best, I think, certainly of what I've seen. And most of those who voted against it were the developed nations in which the transnational corporations are based. I fear that we may end up with a weak treaty with few ratifications. And that might actually end up being worse than no treaty at all. But the question is, I think, is there a risk that the momentum that's been generated by this process might not in fact lead to increased remedies for victims?
Genevieve.
With regard to the question on the treaty, the votes, and the fact that the EU has threatened not to participate in the discussions, I think it is certainly concerning that we're talking about countries where the majority of companies, multinational companies, are registered, and I think it brings us back to Seema's point earlier on the influence companies can have on states, but we wouldn't be worried that it can be worse than what we already have. Like I said, we really one of the reasons why the EU, or that the reason that they bring forward to have voted against, is that it was too early in the process and that the UN Guiding Principles were only adopted recently. There is a need to further assess their effective implementation, but some of us, including FIDH, have, based on cases on which we've worked, have assessed how the guiding principles are being implemented and try and highlight some of the protection gaps that remain, even when we talk with companies that are familiar with the guiding principles and states that know their content. I'd say that, of course, like I said, it will be crucial to make sure that it's an inclusive process, and we are calling on the EU and the US and Canada to make sure that they participate in that process. And often NGOs have been accused in the past year of wanting to polarize the debates, but in this situation, we would say that the EU has a responsibility not to insist on the divisive nature of the vote and to join the participation, especially since they have said in discussions and including in public positions that they are not against a treaty per se. And so with that in mind, we would encourage them to fully participate in the negotiations as well as companies. And we can already see some of the dynamics or the consequences of these discussions on that second resolution with, for example, proposals that Norway have included in its own resolution on the focus on access to remedy. And this focus wasn't planned before these discussions. And so I would say that that's also positive. And we hope that we can also insist in our discussion at the national levels on the third pillar in the discussion, for instance, on national action plans.
Thank you. Louise Winstanley from AB Columbia. I was quite interested in the discussion around the bribery law and the way in which you correlated it to how it could maybe come across to human rights. But I was wondering if it might be used in another way. One of the situations we sometimes work on are mining corporations that are in indigenous territories. And if I understand rightly, because I'm no lawyer, about the Bribery Act, it's the bribery of officials. And I was just wondering whether you could apply it in terms of officials within the indigenous communities being bribed by companies, because they're very often responsible, the authorities of indigenous communities, for those communities. So I'd just be interested to know whether it's possible to use it in that way, because we've seen cases of where companies have tried to bribe leaders of indigenous communities and the kind of problems it's then caused within those communities in front of the mining corporations getting more access to their territory.
Thank you. And then finally, a quick remark from Peter, then we'll go straight back to the panel, and then you'll have your cup of tea. David, your final remarks, please.
Just on the question of whether a person who is holding a position in an indigenous community is a person who might be bribed so as to give rise to liability under the Bribery Act, the answer is yes. Such a person might be a relevant person performing, as the Act puts it, a relevant function. So if the function is expected to be performed in good faith, if they're expected to perform it impartially, or if they're in a position of trust by virtue of performing it. And so persons in indigenous communities could clearly fall within those sort of functions. Anyone with a role where they're a decision maker, which they have to exercise in good faith, or they've been trusted with that, that would engage the provisions of the Bribery Act.
Get a little more understanding of the scope of the French proposal and how it fits in to other things we're hearing about. There seems to be a clear contrast between what the French proposal is and, say, what we're hearing from David about the way responsibility could happen. It looks as if the French proposal is driven by the wrong. I mean, if there's an attack on health, environment, or human rights, then pretty easily the responsibility right up the chain to the parent is triggered. Whereas here we see with David and indeed with Chandler, a further set of limiting criteria, saying, well, even though there are these types of damage, we're going to demand certain kinds of linkages between what parents do and what the subsidiary does. There must be reliance, there has to be the same line of business, etc. And if that's right, I do wonder where we go from here, because, and it actually connects up with what Seema was talking about, and maybe I could ask Seema, would the French proposal, for example, satisfy your objective of, say, triggering a duty of care when you see a human rights abuse as on the line, or would you be more favorable to the more cautious, tailored approach that we see coming out of the UK?
Thank you. It's a radical suggestion asking another member of the audience. My God, whatever next.
Okay, very quickly. I mean, I like the French proposal. You know how it's been. I've seen the English version of a few of the provisions, and I think that I mean they are broadly stated, which I think is interesting. But at the same time, I actually had understood David's sort of three approaches. You know, so the third approach being, you know, a duty of care where there would be an imposition of liability on the defendant unless they could prove that they essentially fulfilled their human rights due diligence, you know, so there is therefore the reversal of the burden. So I like that because it's also, there's a precedent in the UK. So in a way, our recommendation is intended to be what could be achieved within that jurisdiction. So if the precedents exist in both for a different, slightly different approach, we favor it.
Well, no, just to say, if I correctly understood, I mean, from what Seema said, this is actually the French proposal to have the liability on the mother company for the activities of its subsidiary, and so the burden of proof lies on the mother company or the buyers. So I don't see a difference with the third proposal of what was discussed.
I understand that there's an offence of benefiting from the proceeds of crime. Could that offence under UK law be used against companies in a human rights context?
In relation to the offence of receiving benefits and proceeds of crime, I think that's a more complex issue. There are very broad offences in relation to proceeds of crime, money laundering and so forth, and I think that was mentioned in the first session as well, the possibility of following models in relation to that. There's clearly work that can be done there. An appropriate case might catch an offence of that nature, but of course it's not going to give rise to civil remedies. We're still dealing in the criminal sphere.
Thank you very much.